Hi, I am Jonathan Rosenfeld, and today on the Personal Injury Podcast, I am joined by attorney Haig Himiden. Haig is a experienced trial attorney in Chicago, and I am looking forward to talking with Haig today about one of the most important issues coming up in a personal injury case. How a case gets resolved and sort of the timeline for settlement. Haig, thank you so much for joining me today. I appreciate it. I look forward to talking with you.
John, it's an honor and a pleasure. Thank you so much for having me.
All right. Hi, let's now you sit down with many people each year. You handle the intakes in your law firm, and you are the person who's sitting across the desk or on the phone with people after an accident. And I know, having spoken to many of these people myself, a lot of times there's questions about, the value of a case, and when the case will get resolved. Now, we spoke earlier about valuing personal injury cases. People can go back and listen to that segment. But I want to talk with you now about what people can expect in terms of a timeline for resolution. Okay.
Sure.
Um, you know, and ultimately, obviously, people want to get their case resolved quickly. Lawyers want to get their cases resolved. The truth is that there has to be a, everything is a process, and there you have to follow the process in order to do things the correct way and maximize the value of a case. So today I want to talk with you really about that process. And to begin with, I want to talk with you about the role that medical treatment plays in the outcome of a case, and really not the outcome of a case, but how it impacts the timeline for resolution.
Yeah, absolutely. So, again, depending on the nature of the case and the nature of the injuries, it really will dictate how long potentially the treatment will last. And it depending on the injury too, it also makes it's a strategic call to see, how we're going to approach that in a case by case basis in terms of whether or not we're going to file a lawsuit or if we're going to try to resolve it on a pre-suit claim, trying to resolve it with the insurance company, which has significant advantages, including time, which is a big part of it. But on top of that, when it comes to costs as well. So medical treatment, let's say if we're relating it to a very extensive debilitating kind of injury, typically when we're talking about, on the other side, we have, let's say we're fairly confident there's going to be a substantial amount of insurance coverage that's available to compensate them for all their medical bills, their lost time from work, their pain and suffering, and all of that. Potentially speaking, we may want to end up, strategically speaking, filing a lawsuit so that we can take it to court. And if we're in court, we're sort of at the mercy of the court's schedule. So sometimes it could take a little bit longer to actually resolve in that own context. But medical treatment related to that is going to be a subtext to that. And it really comes down to how much extensive care is going to be needed to see how long that is going to add to the overall damages of the case. The medical treatment will go on, and technically speaking, the overall case timeline may not be affected by that one-to-one. In some other cases, when we're talking about pre-suit, we may be talking about where if we're dealing with a situation where we want to wait until the client is done with treatment before we start negotiating with the insurance company, it's almost entirely contingent on how long that treatment is going to last. And if we're talking about conservative treatment, we may mean 4 to 6 weeks of physical therapy. Maybe that's all of it. Maybe we're talking about that on top of maybe some pain management, so it can add several months on top of that as well. But usually we want to see the full picture of our client's treatment. So we may want to wait until that client's done with treatment before we start negotiating with the insurance company or the at-fault party in terms of trying to get the case resolved. So that's going to play a big part of it in that context and in both ways of looking at it.
Okay, so let's say we're talking about an auto accident case. Someone's involved in an accident. They may injure their back, their neck. They do physical therapy. They may need to see an orthopedist, but they have some relatively conservative treatment. After they finish that treatment, assuming that things are relatively straightforward, there's we have a grasp of their injuries. Then you go and then you approach an insurance company, for the responsible party. When you approach that insurance company, talk a little bit about what's involved with, negotiations and sort of what you do in terms of gathering documentation, and actually approaching the insurance company. It's not like you just pick up the phone and be like, "Hey, it's Haig. Uh, you want to talk about, what's going on today? You want to talk about the weather?" You have a process for it. Can you talk a little bit about that process?
Yeah, I mean, when I approach an insurance company and for my client's benefit, I want to show them how strong of a case that we have. That if they don't want to negotiate with us, well, guess what? We can take it to court and we can get what we're looking for out of that aspect of it as well. It gives them that much more incentive to try to resolve the claim with us before ever having to go down that route and actually offer an amount that's more reasonable to the level of damages that we're claiming was as a result of their insured's negligence. And so what we would do is when a client is done with medical treatment, we gather all of their medical records and bills. They sign off on HIPAA authorization forms when we first sign off on the case and we're working on the case. That allows us to get medical records and bills and talk to doctors to get opinions as to their injuries, the substance of their injuries, and potentially what could be ramifications down the line. When we have that all in hand, and then we have the liability aspect in hand, sometimes insurance companies accept liability when we're talking about a very straightforward case like a rear end collision, which 9 times out of 10 is going to be on the fault of the person that hit the individual that was in front of them. So if that aspect's out of it and we're only talking about medical bills and all of that, we send that along in basically what we call demand. We demand an offer of settlement from the insurance company within the policy limits. Sometimes, depending on what the policy limits are, we ask for the entire policy. And then sometimes, depending on what we're looking at in damages, the nature of the case, the overall well-being of the client, maybe we ask for somewhere within those policy limits. And we try to negotiate with them with everything that we have in terms of the documents that we have to show for them. And then we also basically, it's a sense of letting them know that we are trial attorneys. We have taken cases like this to court in the past, and we will do so again here. But we're trying to save everybody cost and time trying to resolve this. And most insurance companies are receptive to that, depending on a case by case basis.
I think one of the things that I really respect about your law firm is that you guys really walk the walk. There's a lot of lawyers out there who are like, yeah, I'm gonna do this, I'm gonna do that, and when push comes to shove, they really don't do much. Your firm, they try cases. You guys go to court, which is really admirable in today's day and age, because they're really not. It's sort of a dying art. The trial attorney is sort of a dying art. So that's a great thing for prospective clients.
And insurance companies know that too, John. They know the reputation of firm. They know what firms are doing. If they're just, there are some firms out there that are just like looking to make a quick buck, flipping cases and all that. They're like, these people are never going to go to trial. But knowing that there's a proven track record from a firm of going to trial, sometimes getting excess judgment verdicts over what's even in their insurance policies, if the insurance company wants to deal in bad faith and not try to resolve a claim when it's meritorious, that goes a long way. And in the legal community within Chicago and abroad, when attorneys see that it's us that's coming at them, again, we're here at Taxman Pollock Murray Beckerman, it's going to be a different kind of conversation than some other firms, that's for sure.
1,000%. I think insurance adjusters, they see the name, the letterhead, come across their desk. They see the names. It's a relatively small community out there, and when they see the known players out there, the known entities, they know sort of who is sort of bluffing and sort of who is ready to you know bring it. So I think that's a great point as well. Next factor that I want to talk with you about is, now we sort of opened the door a little bit earlier, is the role of insurance coverage in terms of uh, the speed at which a case may get resolved. And people may say, well, wow, you're sort of like, there's a lot of disconnect there. How does a insurance policy impact the speed at which a case may get resolved? And, I'm going to let you talk about it, but ultimately, if someone's got a broken arm and they've had surgery, and they may need another surgery in the future, and there's a finite amount of insurance coverage, there may be $100,000 of coverage. Um, Sometimes that can work in the plaintiff's favor in terms of getting a case resolved faster. How do you see that play out sometimes?
Yeah, I mean, we're going back to the substance and nature of the injury. because there is much more in terms of ramifications of a fracture and surgery than, let's say, potentially sometimes a sprain or a strain, which, if you're a normal, healthy person, a lot of times, you give it time. It takes time to heal, but it does heal on its own. But obviously, if you're involved in a case, you want to get the treatment that you need to get better faster, and the law actually favors that and can compensate people for that. But yeah, I think it has a huge impact on, let's say, if we're talking about the total coverage that's available in an insurance policy, if we're talking about state minimums, if we're talking about a fracture, that's almost that's it, at least from what I've seen, that is a policy limit case all day, every day. If we're talking about if higher, if we're talking about six-figure policies and all of that, potentially based on the injury itself, it could actually get to that limit as well, which again makes it quicker to actually resolve a claim. We're talking about more significant injuries. Insurance adjusters are looking at these cases. They basically have a software up, they're typing in this information and data, and they're getting, information spit back out at them to say, whether or not this case is worth X amount or how much we should offer and all that. And realistically, if those damages add up, or the potential for those damages to add up is very apparent to the insurance adjuster, that, yeah, this policy limit is going to be met and exceeded, that may make things way smoother, and things can resolve relatively much quicker than, let's say, a commercial policy that could have potentially 7 figures available. And we're talking about damages that are around, maybe the nature of, let's say, into the 6 figures themselves. Potentially, they may not be willing to offer that much more without having us put in more work into it and prove the case up, which means more time to be able to get to that end result.
So in a situation where, you approach the insurance company, the person does their medical treatment, you approach the insurance company, there is no resolution. The next step obviously is filing a lawsuit and, following the litigation process. Unfortunately in Cook County, where we're located in Chicago, it's one of the largest court systems, I think, in the world, if not the largest. And there's quite a bit of a delay from the time you file a case to the time you get an actual trial date. But a lot of times by the time the case gets to that point, obviously they have communication with their attorney. They sort of know what the process is. The attorney can prepare them for, what may lie ahead. I guess when it comes to that situation, obviously not every case goes to trial. But can you talk a little bit about the process in terms of filing a case? Obviously, nothing's going to happen immediately, but what the process is, what someone can expect just in a general nature.
Yeah, and this topic comes up again very early on when we're talking about clients and the potential outcomes and different ways a case can go based on how the nature of the facts play out throughout the course of their treatment and all of that as well. But yeah, and I touched on this a little bit earlier too when we were talking about the significance in the injury and how strategically it makes sense to file a lawsuit sometimes based on the amount of coverage that's available and the level of damages that we're seeking. But yeah, if we file a lawsuit, ultimately, and I'm going to use Cook County as an example here. You file a lawsuit, and I tell this to clients all the time, that doesn't mean you're automatically in court and the case is off and running. Yeah, we got a case number and it's filed, but there's usually about 90 days before we actually get to see the judge for the first time. Now, a lot can happen in that time. The court system basically is now over watching everything that's happening in this dispute between plaintiff and defendant. But ultimately, there's still a lot of negotiation that can happen in the meantime. There's a lot of discovery that can be passed around, information can be passed around. Potentially, that alone doesn't necessarily mean it's going to take years to resolve, but it does put us strategically in a better position to keep moving forward, to keep the case moving forward and get to that end result at the end. I tell people this all the time. Look, strategically, it makes sense to do that sometimes because it goes back to our ultimate goal as personal injury attorneys, which is to maximize the amount that our clients get in their pocket. And so if we're talking about leaving money on the table, if we can resolve something faster, sometimes it makes more sense to spend a little bit more time and work on these cases and go to court because they're going to end up with more in their pocket at the end, and the likelihood of which is much higher. So after we filed the court case, we go to court after, let's say, 90 days. Then there's a process of discovery where we have to show each other through written discovery, through oral discovery, what each side has to bring to the table. The plaintiffs have the burden of proving the case. But then there's some things that also rest on the defendants to come in and prove on their own as well. We go through fact with discovery, which means like bringing in witnesses and talking to the people involved directly with the case. We talk to damages witnesses. We bring in doctors. We bring in experts, to really put the case in a position where either A, we can resolve it before ever having to go to trial, or B, we're in a position that we're going to have a very strong case at trial, which could take time. On average, I would say, 2 years from the date of filing, if we're seeing a case all the way through to completion, is very much on average and on par. Sometimes longer, sometimes shorter. It really just depends on how the case goes.
That was great information. I think one of the things that people really need to know, and one of the things I think they're going to be able to tell from you, is that getting your ducks in a row early on and really pushing your case and getting the records and getting all the materials together is really going to do quite a bit towards moving your case towards that finish line, whether it's settlement, trial, mediation, whatever it is. Ultimately, the lawyers can do quite a bit to push the case forward. And certainly, I think you conveyed that today. You certainly know what you're doing when it comes to, getting these cases to the finish line. So thank you, Haig. I appreciate it. Look forward to talking with you again in the future.
Absolutely, John. Pleasure. Thank you so much.